Hello everyone. In the last presentation, we have seen that a person can be held liable for the wrong committed by others on three occasions. 1 by ratification, 2 by relationship, and 3 by abetment. We have also seen that there are 6 types of relationships which create vicarious liability: master and servant, owner and independent contractor, principal and agent, company and directors, firm and its partners, and guardian and his ward. We have discussed the rules pertaining to vicarious liability by ratification and vicarious liability arising from master-servant relationship in the first part. Coming to vicarious liability arising from independent contractor-employer relationship, who is an independent contractor? He is a person who undertakes to bring about the desired results for the employer. Here, the contractor has control and discretion so far as the manner in which the work has to be executed. The contract is not for work but for the result of the work. It is not a contract of service but a contract for service. Employer will not therefore be liable for the wrongful acts of the independent contractor. However, the employer will be liable to the third party for the torts committed by the contractor when the case is a strict liability case, that is, where intention or negligence is not required to make a person liable for the act causing harm. Similarly, where there is use of fire or the act causes danger near highway, or where the employer does not fulfill the duties imposed by common law on the master or employer, or where he personally interferes in the execution of the work entrusted, or where the work involves danger near another's property and it is done negligently, the employer of an independent contractor will be liable to compensate for the injury caused by contractor's acts to the third party. If the act for which an independent contractor is engaged by the employer are unlawful or extra hazardous, the employer would be liable for the acts of an independent contractor. The next relationship that gives rise to vicarious liability is that of principal and agent. Here, a legal relationship exists between the agent who is authorized and consents to act on behalf of the principal, especially to place the principal in contractual relationship with a third party. An agent is not an employee, but an employee can be an agent. Agency may be an agency of necessity or an agency by estoppel. Agency of necessity arises when a person acts in the interest of another person to preserve his property or carries out his duties in his absence. Agency by estoppel arises when one person had acted in such a way that the other believes that a third person is authorized to act on his behalf and enters into a transaction with the third person. So where A acts in such a way that B believes that C is authorized to act on behalf of A and enters into a transaction with C, here C is an agent by estoppel. A is the principal and B is the third party. Principal expects that the agent would use ordinary care and skill while acting on his behalf and use his judgment and discretion honestly in the interest of the principal. He expects that the agent would keep account of monies received and paid on behalf of the principal. The agent is expected to maintain confidence regarding everything that comes to his notice in the course of agency and not permit his own interest to conflict with his duty towards principal. The acts done by the agent, which are within the scope of the express or implied or general authority, binds the principal in relation to the third parties. In order to make the principal liable for the acts of the agent, it has to be shown that it was performed within the scope of authority, and where the agent acts beyond the scope of authority, it has to be shown that same was implied, authorized, or subsequently ratified by the principal. Even where the act committed by the agent is tortious, fraudulent, or criminal, if the above conditions are satisfied, the principal would be liable to the third party. Agents may be public or private. Government servants are public agents. Private agents may be general or special. General agents are appointed for doing certain class of acts. Special agents are appointed for a particular work or act. Private agents are liable to third parties for acts of misfeasance and not for acts of nonfeasance. They are liable only to the principal for illegal omissions. Where the agent commits fraud, that is, deception, resulting in wrongful loss, he is personally liable to the third parties. The plea that he was acting for the principal cannot be taken because contract of agency does not impose an obligation to commit fraud or assist in committing fraud. Private agent has a right to remedy against those who invade his right of possession and against those who impose loss or damage on him by committing a tort. As public agents, government servants appointed by head of department cannot make the head liable for his acts because there is no master-servant relationship existing between them. They are fellow servants under one master, that is the government. They obey law and not the order of the superior. They bind the government if they act within authority, but when they exceed it, they bind the government only when the government expressly or impliedly ratifies it. When the government acts in exercise of sovereign power through its servants, it is not liable. Regarding vicarious liability that arises by virtue of relationship of company with its directors, a company is liable for the negligence of its servants and for torts committed by them in the course of their employment. The relationship between the company and its directors is governed by the principles of agency. Directors are personally liable for the torts committed by them, even where it benefits the company because the contract of agency or service does not impose an obligation on the agent or servant to commit fraud or any tort. Regarding firm and its partners, partners collectively constitute a firm. All partners are principals on their behalf and agents on behalf of others. All the partners of the firm are jointly liable for the acts of the firm, and the firm is accountable for wrongful acts done by the partners. The business of the firm is transacted through partners, and tort committed by any partner in the course of business makes the firm liable. The liability of the firm is based on principal-agent relationship. Now, so far as guardian and ward are concerned, a father is not a child's master and guardian is not ward's master unless they are in fact servants. Therefore, a guardian will not be liable for the tort committed by his ward. But where the ward acts as an agent or as a servant of the guardian as a principal or master will be liable for the tort committed by the servant. Where the guardian, because of his own negligence, provides an opportunity to the ward to commit a tort, the guardian would be liable for it. Vicarious liability can also arise by abetment. Now, what is abetment? It is exciting, provoking, encouraging, or promoting the commission of a wrongful act or an illegal omission. Abettor is the person who instigates another person to commit a wrongful act. As in crime, so in tort, abettors are equally liable for tort along with those who actually committed the wrongful act. This, in brief, is how the principles relating to vicarious liability work in law of torts. Thank you.